When clients come to the O'Brien Law Firm, our first and really our only concern is representing them to our absolute best of our ability. And some clients wonder right away, how much do I owe you? How much do I owe you for this meeting? How much am I going to owe you next week? How much am I going to owe you next month? And the answer to that is nothing. We work on what are known as contingency fee agreements. We will take a percentage of any recovery that we are able to get for a client. We don't do retainers. We don't ask for money out of your own pocket for filing fees, for expert witness fees, for medical record retrieval fees. If we don't get real compensation for you, we don't make any money and you don't owe us anything. We look at a lot of cases that a client believes they have asbestos exposure or they believe they have asbestos disease, and it turns out to be the case that they don't. And we have spent money in getting medical records and having the records examined by expert witnesses. We don't charge for that. The process can be very difficult for people because they're dealing with a bad diagnosis or a bad injury. The last thing we're going to do is bother you with costs and fees and retainers. When we recover money for you, that's when we will recover costs and recover reasonable fees that I think are very fair. We've never had a client tell us, hey, the case is done and this was not worth our time because of the expenses and the costs and the fees. Quite to the contrary, most of our clients, if not all of them, are pleasantly surprised at how little they were charged for our very important services.